maybe it's the
Yes.
item number 1 and 2. I am not getting the matter. There's some instructions because both of them have shared.
Okay. Learned counsel for the. You are not pressing the IS.
Nothing, man. Entire matter is
Okay. Please लिखिबो. हाँ. Learned counsel for the Mr. K. Bhattacharya, learned counsel for the petitioner submits that he has instruction not to press the present writ petition. Accordingly, the writ petition stands closed, not being pressed.
honest.
Same order হবো দুইটাতে লগত I দিব in view of order passed. In view of order passed in writ petition, I stands closed.
How like
May I please, Your Lordship?
Yes.
Lordship, with the consent of the other side, I'd like to mention item number 12.
Item number 12.
Lordship, may kindly adjourn the matter for 10 days and be placed on the better
You are for
respondent number 4 to 11
BTC.
for Karbi Anglong Autonomous Council on behalf of Mr. J.
You wait for some time because you made a statement before the court that you have received the instruction and you will file an affidavit shortly.
Lordship, since the secretary and the joint secretary are completed.
We do not know. You made a statement. Wait for your turn.
allowed to for lifting of the one petition that is of 695 of 2004 for EAD.
No, you cannot make a mention relating to which bench? Bench three.
Armed forces.
Huh?
Armed forces service.
Go to the senior bench. Yes.
Lordship, Chair, I beg to mention Chair Division 206 with bail application 33356. Matter is part out from this. Lordship. 20 Chair Division.
Okay, we'll just give the number. We'll verify. Give the number to. We'll see when it can. Yes, Mr. Vaishya.
Well, item 8 may be taken up next week. That record has come, Lord. Next month,
Okay.
this week I have little bit.
Okay. Just wait for a minute. We'll just pass the order referring to the earlier order.
Beg to mention item number 5. Learned English Council will not attend to it.
What remains in this case?
Any idea? Inform you about it.
We have idea. We'll dismiss it. You earlier approached this court. This court allowed your writ petition. Division bench upheld decision. Supreme Court set aside and said you cannot claim this salary. Now there is a proposal by the government for restructuring of the cooperative. There is no scope for direction, again issuing a direction for payment of salary. This is pending since 2019.
I don't have any idea. Inform me about
But this is the last chance.
kindly for next.
Okay, next week on the prayer of the learned council. Yes.
Search is submitted.
Yes, search is submitted.
Search submitted.
438. No interim. It was earlier rejected, isn't it?
Lordship.
Okay. खाली একটা পরে একটা order. CS number.
CS number is 878
Hmm.
stroke 2023 dated 31/10/2023.
Okay. Close. Petitioner shall be at liberty to approach, not direct taken. Shall be at liberty to approach or enter. Yes.
May I take the purpose? Implement of implementation paying for implement respondent of respondent out of new content history of
for earlier.
When have you intimated the new incumbent that order is not being complied,
That,
or is the statement?
that, my lord,
How will the officer know that this is a pending my EPS?
after
Newly come-
filing this contempt petition,
Hmm.
it is come to know.
How? Tell us.
There are
how.
two.
Huh?
After filing the contempt petition, the applicant petitioner came to know that the name of the earlier respondent complainant has been wrongly written. Because the earlier respondent, Dr. Paresh Sharma, was the additional director of Animal Husbandry and the veterinary Assam, Khanapara, and not the director of Animal Husbandry and veterinary Assam, Khanapara. When
Now,
the,
where is now you want to implement whom?
Ashok Burman, Dr. Ashok Burman.
Director of
Ashok
Animal Husbandry.
Yeah.
Where is that statement or proof that you have served a copy of this order asking to implement before Ashok
As per
Burman?
order of this Honorable High Court, my lord, the copy of order dated, it is, from the after, Annexer B. Annexer B, my lord. The copy of order dated 4/10/2023. Passed from the Nang,
Page,
10/11,
page.
10/11. 10/11.
This is to the 10-11.
Pardon? Mr. H.S. Tamili, learned counsel appearing on behalf of Mr. S. Sharma, learned counsel for the respondent submits that the present respondent has been wrongly implicated as he was never holding the post of a director of Animal Husbandry and Veterinary Department.
No, that we understand.
Hmm.
You communicated to the director on 22/5/2018. Where is your statement that this Ashok Burman was a director at that point of time?
Possible or not? It is some other email.
So Ashok Burman was-
Paresh Sharma,
Ashok Burman was not there.
not there.
Now, have you brought to the notice of Ashok Burman that this order is to be complied with?
Hmm.
Tell us.
Yes, my lord. The order is fine.
No, order is there, or many orders are there, but the officer must know it, that there is an order.
Hmm.
And I have to comply with.
Hmm.
Where is that statement of proof that Ashok Burman is aware of that?
The learned advocate of the respondent, my
That was 2018. Admittedly, Ashok Burman was not the director at that point of time.
lord.
How can we issue a notice in a contempt?
Niti was content, my lord. But after it is come to know, my lord.
No,
My
you have come to know, but Ashok Burman has not. Problem is this. Isn't it?
Now,
You are aware that Ashok Burman is to comply with this order.
oblige, my lord.
But Mr. Burman is not aware that he will have to comply with this order because this is an order of 2018. He came into the office later on. How can we issue a notice?
My lord, Paresh Sharma was additional director on that time. It is wrongly written as Paresh Sharma as the director of a director.
No, we understand. Forget about Paresh Sharma. Paresh Sharma will release. What about Burman?
Now, Burman is my.
Burman is aware.
Number one, Burman is,
Understand how Burman is aware.
my Dr. Ashok Burman is not present. Director.
No, we understand. Give us a statement or any proof that you have intimated Ashok Burman that this is the thing. Court has passed this order. You will have to comply with it.
Oblige, my lord.
Where is that? This is a contempt you have made, not the director, the person as a party. You are strict in contempt. No, you will not issue notice in this case.
My lord, Ashok Burman is now director, my lord.
No, maybe.
My lord, accordingly, it is permitted.
He may be director, but we must know and satisfied that even after knowing or his knowledge, he has sitting over this matter willfully, deliberately, prima facie. Thereafter, we'll see later. Learned counsel for by this IA, the petitioner seeks to implement the present director of Animal Husbandry and Veterinary, Assam, Khanapara, as a respondent in the connected contempt petition. Full stop. There is nothing, no material, nothing, no material is available on record either in the shape of pleading or any document to show that the present director was made aware of the order dated 4 order dated 6/12/2017, comma, which alleged to have been violated by the director. In the view of the matter, the learned counsel is granted a liberty to intimate the aforesaid official as regards the order dated so and so and accordingly the IS stands closed. You first give a notice to him. If he complies, then it will be closed. If not, then only we can allow it.
Lordship, there is an office note of 3/1/24.
Hmm.
So earlier counsel expired, so register notice was sent through the registry document, but neither answer notice nor anyone had appeared.
On 5th of June 2012, mother was
Yes.
80 years old
Now she is 90.
and no notice. Will for a time being dismiss it for default. If somebody
Yes.
comes, we'll respond. None appears for the petitioner on fault. Seen the office note dated, seen the order of the Laojima court dated 3/1/2024. As none appears for the petitioner on fault, matter stands dismissed for non-prosecution. We'll see. Since it's a pension, we'll see later. However, the Sharma learned 3 days. Yes.
Lordship, here the matter pertains to payment of honorarium to village health guides, my lord.
Okay.
Regarding this, my lord, we have formed a committee and the process of verification is going on at the moment. Lord.
Okay.
So we just seeking some time, Lordship. So in the 3 weeks time may be granted, Lordship. To try to comply with the court's order with.
You have constituted a committee.
Yes, Lordship. And then there has been a report that has been submitted to the government also. So basically a verification stage is going on, Lordship, because some of the members have expired. So the heirs, legal heirs have also to be verified.
Mr. Chaliha, learned counsel the learned counsel appearing on behalf of the health department submits that a committee, a 3-member committee has already been constituted to look into the proper compliance of the order dated 26/2/2016 passed in WPC number 847/2014. Now, what is the stage
Your
according to?
Lordship, they're verifying because the report has already been submitted regarding,
The committee has already
submitted a report to the government, Lordship.
submitted a report in this regard, and the government in the health department
Yes, sir.
is considering
Yes.
the aforesaid report at this stage, and same will require some further time.
Yes,
Accordingly, Mr. Saliha prays for adjournment of this case
Yes.
so that he can apprise this court regarding the present status of the such considered. Full stop. Prayer is allowed. Please this matter
after 3 weeks, Lordship.
after 4 weeks. On a date to be fixed by after 4 weeks and on given. First of March. Yes, Munir.
Which note? Sub notified.
So what to do? Because might be they might not be still continuing 7 and 8.
They were completed later on earlier. Something that they were
Where is the order?
direct
Where is the direction?
74 matter. Normal pension and gratuity matter that has paid matter only the interest for this paragraph 41.
Who will calculate the pension?
Those part has been done. Given.
Huh?
Pension and gratuity.
No. Your grievance is that 9% interest. Who will calculate? Who will give? Who is the authority?
Quality
Because
cooperative
Register of Cooperative Societies. Then why this commissioner all are necessary?
not required.
Okay, call the cooperative department, any standing council.
End of the part.
If you can bring them
Well,
immediately. We'll
I'll
see.
look.
Standing council for cooperation, Mr. Devnath was there. Or anybody? MD Bora, call MD Bora. Call MD Bora. These matters should not be kept pending.
I think the matter now almost become instructed. The petitioner asked the patient also it is not here. Petitioner has been selected.
None appears for the petitioner on call. None did represent the petitioner on 14/11/2022. Full stop. Accordingly, the matter stands dismissed for non-prosecution. Interim order passed earlier on 31/7/2017. Interim orders passed earlier shall stands vacated. Huh?
2 days time maybe.
No 2 days time. How much cost will you pay? Tell us. Why should we issue a contempt notice at this stage? You have not taken steps. Who knows that these officers are there or not there? Are you aware that these officers are there? Do you have any contact with your client? Huh? The learned counsel for the petitioner submits that she may be granted 2 weeks time to obtain instruction whether anything survives in this contempt petition. Prayer is allowed, list accordingly. Yes. This is item number. Where is the order?
Starts at page 9.
Yes, 9.
Page 9 and the operative part starts at page 11. Regarding appointment terms of the under the Assam Public Service
Wait for time. Come in. Kindly pay to order dated 29/2023. Lord.
No, no. Here is a direction to consider your case in terms of Assam Accord, that rule to 1999. Rule 99 I shall be applicable when there is an advertisement, isn't it?
Yes, Lord.
accordingly I have submitted my application and accordingly the are making appointments in terms of the rules those who have applied. I have annexed all those documents with it.
I have not received that copy. Lord.
I
And
have
Lord,
filed on 13/10 on affidavit.
main respondent is DC Lordship, and I also not received that I am appearing. I am respondent number 5, main respondent is DC Lordship.
Which is the department?
Assam Accord. Assam Accord Department.
No, no. Assam Accord department is the who has formulated the rule. Now, rule is made applicable in all selections, but you must have the other qualifications, isn't it?
Yes.
There is a quota for you only. So there cannot be any appointment as such in your favor.
What I appear. Okay.
So affidavit has been filed by the Assam Accord implementation.
Stated that free and
There is no contempt, we'll have to close it.
check that file. I've annexed all the advertisement at the my application form, the RTI application and the appointment letter immediately situated all the they are
Challenge them.
no lordship, I'm not against the
But suppose, how do you know? Suppose there is an advertisement. You are also a entitled for benefit under that rules. She is also entitled under rules. There is one earmark vacancy for that category. Suppose she scored higher than you. Okay. You will have not an indefeasible right that because of you are a victim, your family was a victim of Assam movement, then you'll get an appointment. There will be competition amongst the class you belong. So you may say that her appointment is wrong. Then you'll have to challenge her appointment. But if not, then how can they might have considered? So you participated in selection. Somebody is selected. We'll presume that you were not selected. Where is the contempt?
Intentional and deliberate non-compliance.
Where is the contempt?
my application that that there is a vacancy also. And then
No. It's not a question of vacancy. It's a question of selection process.
preferential treatment
When there is an advertisement, you will apply a quota is earmarked for you. Your cases will be considered against those quota. Suppose 5 posts are earmarked for the quota. There are 10 people. 10 will not get. Top 5 will get. So these cannot be determined in a contempt. They have taken a specific stand, and they have relied on a judgment which lays down the ratio. And your case, there is a direction for consideration. In those 4 months, your cases could not be considered. Matter ends there. Why don't you file an affidavit?
Lordship, it is other appearing for that. We have had earlier contempt for people. We are not implementing it. I'm
Because we cannot make a roving and fishing inquiry
Mr.
because
Bhagavati is appearing for
Huh? No, we do not know. This is not a contempt. Come prepared day after tomorrow. Okay, next week. Come prepared. There is no contempt. Come prepared. With contempt, we cannot decide all this whether MSK Talukdar Learned Council for the petitioner prays for and is granted an adjournment. Stop. Please this matter next week.
But-
Keep it here. Take this. Fifth of Feb.
in this contempt,
this-
Lordship, I am
Item number
29. Lordship. I am appearing for respondent, but respondent will have to file an appeal, Lordship. Our earlier review petition has been dismissed by my lord. Thereafter, we prefer to file appeal, Lordship. Appeal is in delay continuation stage, Lordship. It is fixed on 2nd of February.
There's a delay of more than 2 years during the appeal. The order is of 2018. There's a willful disobedience of the order passed by the Honorable Court.
See, even contempt, there is an order.
We have filed affidavit in our concept
Yes, same statement you have made on 23/6/2023.
lordship, but this is
So don't repeat all those things. That has been recorded and there is a direction.
lordship, but notice staff lordship delay is yet to be condoned, and we have filed our affidavit in
Same
opposition.
has been reflected in order dated 23/6/2023. What have you?
Affidavit in opposition, there is no deliberate and willful violation of the order, Lord. Kindly page our affidavit.
Where is the direction? Tell us.
Page 21, but paragraph 6. Paragraph 6, summary.
Where is that order dated 20/2/2017?
Page 15, but
What was your grievance?
our grievance was my lord 28 numbers of posts were created by the state of Assam with an understanding that all the recurring expenses be incurred by the
Okay.
BTC.
Mm.
Pursuant to a memorandum of understanding entered into between Assam government, BTC and the NTP.
Okay.
So we have been working in this ITI Salakati since more than 10 years, 15 years, 12 years, respectively. So we have been working in the same capacity. Had this post been created and this order would have been, my lord, executed, we could have been appointed or regularized in the same department.
Where is that?
But there is no such direction for us. But since we have been working in the ITI Salakati since more than 10 years in the same capacity. The post were created.
Is any determination that
there
you
is
are
no-
entitled for this
No,
post in the
I am not saying
repetition?
that I am entitled. I am entitled to the post that would be created by the state of Assam and subsequently executed the PTC. But here is the order passed by this honorable court. If they implement the order, my lord,
Mm.
and if they execute the order dated February 27, perhaps there is a chance that we might be regular.
No, we cannot run on perhaps in a contempt petition, number one, even in repetition. So no substantive right has been decided on your part.
But nevertheless, there is a direction passed by this honorable court to
But
implement
directions must be implementable.
it. Yes.
It must be implementable.
But this order is
Certain orders are non-executable.
But this order is can be implemented. This February 27, the post were created by
Now,
the state of
posts are
Assam,
sanctioned by the government.
government of
Salaries, all are is to be given by BTC. BTC says, no, we do not need post where we don't have money.
Financial.
Can court issue? No, you have it, you have your,
the court issued the direction pursuant to
issue the direction, but cannot be complied with.
but there is a memorandum of understanding entered into between the parties and they have agreed.
Understand. Everything is there. But there is no direction as such for determining any right.
But in the order, no rights in favor of us were created. But so far as the order is concerned, my lord, it is very clear to implement the order at 22/27. And since we have been working
Orders must be, violations must be willful and deliberate. We do not find this order to be an implementable order.
if I may take your lordship to the memorandum of understanding page 12.
Understand? At your behest. It's a memorandum of understanding between BTC and state and that, where is that?
NTPC, page 12.
NTPC. Okay, where is the, anything so
Clause-
far relating to you that,
No, so far we are concerned, there is no clause regarding us. And it's a common memorandum under
where is that clause regarding creation of post?
clause 4, my lord. After the construction of ITI is completed by the third party, the same shall be handed over to the second party. The second party shall appoint engage
Which second
instructor.
party?
Second party is BTC. The second party shall appoint, engage instructor and other staff as per norms and shall bear all the recurring expenses such as payment of salary and other administrative expenses for running the institute. There is no financial implication on the part of first party, that is the state of Assam, in terms of creation of post or maintenance of the institute. In view of that, my lord, on the second party, in the clause clearly says the second party shall appoint, engage instructor.
Ah,
And in view of that, this notification was issued, the order was issued by the state of Assam, creating 28 number of posts in the ITI Salagati.
I'm not understanding why state of Assam need to create a post where they have no rule. They say we wash off our hand. Whatever you want to do, you do.
Because there were representations filed by the BTC authority themselves for creation of posts.
Okay, posts are created. They are not inclined to appoint. What to do?
Financial is not with it.
Those
They
were
have violated the memorandum of understanding between
But-
between them and the state of Assam. Now, can we direct at your behest to implement that memorandum of understanding?
the direction is not for the
So if no direction can be issued, how can we say create a post?
posts are created. Only that they have to implement the order passed by the state of Assam.
What is that order?
But this is the order 2020 February
Where
27.
is the implication that that they must start and create the post?
If I may read, my lord, the order.
Yes.
I am directed to convey the sanction. Page
Okay.
15, my lord.
Okay.
Page 15.
Page.
15.
I have doubt, Mr. Vishwas.
I am directed to convey the sanction of the governor of Assam to the creation of 28 number of posts for ITS Salagati as given below under Labor and Employment Department of BTC during 2016-17, subject to the condition that the BTC authority shall bear all the recurring expenses such as payment of salary and other administrative expenses for running the institute, and there will not be any financial implication on the part of state government in terms of creation of posts or maintenance of the institute. But the BTC authority will not ask for additional funds for the purpose such as payment of salary and other administrative expenses for running.
Can we understand?
Well, the
In terms of the agreement, what is the agreement?
memorandum of understanding.
Who is third party?
Third party is my lord NTPC. The
Second party is BTC.
second party is for creation of the post. BTC themselves took the initiative. There were several representations filed by them before the state of Assam. We have annexed the decree.
See, somebody build a building, third party. First party says, okay, we will have no responsibility. You run, we will give only permission. Post, everything is yours. Now, government says, okay, these are the posts created, but no financial implication. Now, suppose they do not want to run with the ITI or IIT, whatsoever, ITI. Can we direct? No, we will have to run by engaging.
But they have
Can a read be issued? According to us, this read is not executed.
they filed a review petition taking the same ground, but their review petition was dismissed, saying that no review lies on the facts and circumstances of the case. They did not raise all those plea before the read court. Subsequently, they filed a review petition. They did not prefer an appeal challenging the order passed by the Honorable. Rightly or wrongly, my lord, there is a order standing against them. My lord.
But a person cannot be punished rightly or wrongly in a contempt.
Never.
Contempt is a quasi criminal. We'll have to have a satisfaction that yes, it is, if we have a satisfaction disorder, there are good reason not to implement. You can close it.
But their only reason is that they do not have the financial capacity. But they,
Can we say that no, you have, you do it? Forget about your financial capacity. Can we say in a contempt?
at the same time,
That can be a very good reason because contempt of court itself says good reason can be ground to say that this is not will.
but in the read petition, in by of an affidavit opposition, they never took such kind of plea, my lord, before the dispute.
That time they might have a idea that will be able.
And they did not file an appeal also.
Do you suggest that in financial things like this we can say no, create the post, pay the seller in a contempt petition? And in a writ petition order has been passed, they are coming with a good reason, we don't have financial capacity, we will not continue with this. Can we say no, you will have to because you have given? Think over it. I have a serious doubt. Contempt is a serious matter. We will not spare anybody if there is a violation. But at the same time, on mere asking, it's difficult. On the prayer of Mr. M.S.R. Bora, learned. Who needs to file affidavit?
We have
They filed.
that MOU is already expired. It was for only 5 years.
No, question of not expiring. What is your explanation regarding non-implementation?
Lordship, I
You
have
say
explained-
that we have good reason not to
I have
implement
explained.
and will not be able to implement. Do you have that?
Yes,
Have you
Lord.
taken that stand?
Yes, sir. In
Where
our
is that?
affidavit, we have stated. Paragraph 5, 6, Lordship. And paragraph 6, Lordship, page 27, relevant portion. It is pertinent to mention herein that
Yes, space.
page 27, Lordship. Running page. It is pertinent to mention herein that ITI is an interested subject of PTC per MOS 2023 and like there are 39 interested subjects. So far,
How are you appointed?
Were appointed, my lord, without any advertisement. That there is an order passed by the PTC from the Secretariat of PTC. My lord. It is available at page 8 by contempt petition. It is in pursuance to the recommendation of the selection committee for selection of faculty to the ITS.
How your selection was held? Let us not dig deep inside.
Appointed on contractual basis.
Let us not dig inside.
they were
I have doubt it is not contempt. R. Bora. Matter stands adjourned for 3 weeks.
Like,
This is next week, my lord. This is a contempt matter where we have paid 10 lakh, an odd amount, my lord, and 10 lakh remain, my lord. So I'll take specific instruction, my lord, so next week.
Mr. J. Roy, Learned Senior Counsel, prays for and is granted
1 week.
1 week time to obtain instruction. To obtain instruction
with regard to balance payment.
with regards to balance, with regards to payment of balance amount of rupees 1029,301, 1029,301, comma, which is reflected in this court's order dated 9/10/2020. Please take on.
Okay.
Everyone, I require some time, my lord, I take some after inspection. We are not objecting to anything, but it's regarding granting of MSCPS. Meeting has to sit. I have to take after inspection whether it's set or not.
Mr. Gogoi, learned counsel, appearing for respondents. Prays for further time to obtain up-to-date instruction as regards meeting of the committee to determine the meeting of the committee as regards determining the payment of financial upgradation to the petitioner in terms of this court's order dated 10/1/2022, passed in WPC 2368/2020. List after 2 weeks.
Hold it.
Have it. Where is the order?
Yes, Lordship, page number 27, Lordship,
Page 27 of the order is the part.
operative part is fifth line from the top, Lordship.
Page,
Page 20.
Page 20,
paragraph 12.
sixth line from the top.
Beside it,
Yes, Lordship, here I'll just like to add, Lordship, here the health authorities in the health department, they have already regularized the services of the petitioner, my lord. And the only issue is right now, Lordship, that they had sent a proposal to the finance department, Lordship, on 10/11 of 23, my lord. Upon receipt of the approval from the finance department, the pension of the will be finalized within a period of 1 month time from what I've been told. Now, only issue is, Lordship, that the matter is pending in the finance department and they have already sent the EOL proposal, extraordinary leave proposal in case of the petitioner to the government. Now, they're just awaiting and the authorities in the
do you
finance.
have any written instruction?
Lordship, here I have the instruction regarding the regularization I have, Lordship, and the EOL proposal also, Lordship, I have a photograph, Lordship. I have not been, I'll just show it, Lordship.
This court, under its order dated 1/2/2022, passed in WPC 3136 of 2020, 3136 of 2020,
Order.
directed the principal secretary to the government of Assam family welfare within bracket B department to consider and decide the following. 1, 2, 3 Roman 1. Pay for the promotional post of reader with effect from 4/4/2013 till 18/10/20 18/10/2020 within bracket date of superannuation. Next, to consider regularization of gap period from 5/11/2018 till 18/10/2020. 3. Finalize the pension proposal of the petitioner. 4. Finalize the pension petitioner of the petitioner as well as any other retiral dues that may be due to him. Full stop. Next, Mr. A. Saliha, learned counsel representing the respondent, on instruction has submitted that by an order dated 19th of June 2023, the promotion of the petitioner was regularized under regulation within bracket 4D of Assam a PSC within bracket limitation of functions bracket close regulations 1951 51 full stop. Mr. Saliha further submits that in the meantime, for the payment of financial benefits, proposal has been sent to the finance department by the employer department on
10/11/23, Lordship.
on 10/11/2023 along with proposal regularizing the
Yes,
gap
Lordship.
period.
All those will be regularized after getting the approval from the finance
Okay,
department.
with the proposal.
It was a EOL proposal, Lordship,
Okay, with-
extraordinarily.
Okay, with an EOL proposal. Full stop. And the department is awaiting the
Response.
response from the finance department. Mr. Saliha further submits that the department is expecting response from the finance department within a period of
Lordship, we'll send them a reminder, Lordship.
okay
because the-
within a period of 3 weeks. As the respondents are as the respondent has already implemented one part of the order, the petitioner is getting pension, isn't it?
No, Lordship,
Okay.
no, Lordship, because
Okay, one part of okay.
That is-
Provisionally you are getting?
no,
Not provisionally.
Lordship, because the approval,
Okay,
once
okay.
the appro-
Comma, on the prayer of Mr. Saliha, matter stands adjourned and be listed on give a date. 7th of February.
Lordship, slightly longer because we'll send a reminder to the finance department.
Okay, give a
for
date.
Some time. Lordship, after some date after 3 weeks. 3 weeks. 16,
16th of February.
Lordship, after 16, Lordship, because immediately after 19th February, Lordship.
19th of February 2024. Full stop. This court expects that the respondent shall comply with the orders in its proper spirit in as much as the matter pertains to payment of
Yes.
pension. Full stop. Yes.
This is regarding upgradation of the petitioner from work to the regular employee. This petitioner the question of completion down.
Hmm.
But of the temporary
What is the order?
appointment order.
No. This is
Will be
repetition.
on that.
Okay. Why this matter is listed today?
So one
What is the issue here?
issue is also this petitioner was appointed on completion down as was it against the temporary. Subsequently, he filed regular. Yes, sir. The respondent
Yes, who will file response? Who will file affidavit?
who has filed.
Huh?
1 and 2 have filed. See the managing committee. See the managing committee support this petitioner.
Who?
The managing
So do you propose that this affidavit will cover? Respondent number 3 is yet to file.
but he
Yes.
Here in this case, the proposal that was sent by the respondent number 3, that has been rejected at page number 40. Page number 40 is there.
Do you think your affidavit is required?
Affidavit to that actually is not required because
Not because your order is been
rejected.
rejected.
Yes.
Okay, we'll take it
basically
in
they
the
are not
admission
challenging-
stage.
Another difficulty is that they are not challenging this order. This
We'll see
rejection.
that, we'll see that. Okay. The respondent number 1 and 2 has already filed affidavit. Full stop. Affidavit, Mr. Spencer, learned counsel for the respondent number 3 submits that no affidavit shall be required to be filed by the respondent number 3. Full stop. In view of that, list this matter in the admission column after 2 weeks.
Okay.
In the meantime, the petitioner may file reply to the affidavit filed by respondent number 1.
34
34 same. Okay.
apply.
Yes, Mr. Saikya.
In this case, we have filed an affidavit.
Uh-huh.
In fact, by an earlier order of this honorable court,
Hmm.
bail level warrant was issued. If Lordship is pleased to look at order dated 15th December.
What happened is, we then do not want this, but the problem is that many cases this has happened.
No, but this is a case where this gentleman was not there for one long year. When the contempt notice was issued in the month of February also, much prior to that, he left that department.
But no official says he has refused.
No, it is wrong. It is
In fact,
No, no, it-
first we should know, just listen to me. First it was done. Then what happened? I saw in series of cases. So then I requested Mr. Dinat that at least because first the
but this gentleman regularly appears.
might be. That's why we thought that
Lordship will kindly see the office note. Office
Hmm.
note says, notice issued to respondent number 5 has been received back unserved with post
okay, no problem. Okay, no issue.
return to sender. That means the sender was not there. That is why the dispersed section did not receive it. He was in the animal and husbandry department from
Hmm.
1st January 2023. Notice was issued in the month of February and it went in the month of December, October or November.
Because we were getting similar.
So
Because
I am praying for Lordship expunging of those.
yes.
Yeah. Then I have no difficulty, Lordship.
No,
In
no
fact, the
issue.
petitioner should have rightly, this morning also Lordship was inquiring whether that officer is in position or not. And there was no direction to him also in the
No,
context.
in this case, what happened, I recall, I got on the same date itself, many cases. Thereafter also, then I call Mr. Nath. Instead of calling you, I call Mr. Nath. That what happened, this officer only.
This
Then
officer,
Then he said, okay, I will have instructions. So thereafter also, I filed many orders. So we said adjourn it and asked not to have the instruction. This is one. Other, I have seen many officers are directly writing to the with parawise comment.
when he was in the finance department, P. Gogoi and Rajiv Porpuje, they always regularly
Ah,
appeared on behalf.
Uh,
He has no such issue.
Dinath is aware of this issue.
But he
Might be.
in
Anyway,
fact, he
anyway.
is no more in finance department from
Okay,
31st
okay.
December 2022. And 1st January he joined.
Our idea was that, okay, his notice has already been, generally we are a little bit, this court is a little bit strict in issuing notice.
Lordship.
Because until and unless a person is primary
And on top of that, this department is not at all relevant for the pension cases. When there's a separate department, he is wrongly implicated in the writ petition as well as in the contempt petition. And the contempt petition direction was issued to the executive engineer of Rima Hasao.
Hmm.
There is absolutely no role of him.
That's why we have not issued notice in many cases.
Yes, sir. He was finance department is not at all relevant for any pension matter. There is a department called public grievance and pension department. And he belongs to the PWD department here. Administrative department is PWD. Pension and public grievance department is not there. And the direction was issued to the executive engineer, respondent number 3. And this is very embarrassing, Lordship, that a policeman comes to the officer's chamber and wants to arrest him. At least some action should be taken against the petitioner, Lordship. When they made a party, especially in contempt, they should be doubly sure that
I recall this. Because generally we do not like to call these officers. But out of one after another, then
It has to be properly addressed.
Uh.
Why they will shy away from contempt notice? When I am there, Lordship, I assure this honorable court that no officer will dare to defy the order. It may be they may have to either challenge it before the higher court or they have to comply. These are the two options left.
yes, why he is necessary?
When the repetition was disposed of.
No, understand, but
No,
what
my
was the
lord, objection
direction
to that.
issued?
Now, my lord, in contempt petition that.
No,
has
no,
been raised.
let us see, let us
cannot
know.
be allowed.
Contempt, there are many parties. But where is the order to be, who is to implement the order?
That's
Let
what
us see.
Case 16, Lordship will say paragraph 4.
Yes. And we have issued, this is our fault, we have issued notice to all.
And on top of that, this is a case of pension, determination of pension of a master roll worker. Finance department has no role at all to play. In fact, in a writ petition, he was wrongly made the party. I mean the department.
The present contempt petition is filed with the following direction. Page 16, paragraph 4. No, the contempt petition, the present contempt petition is filed alleging willful and deliberate violation of an order dated 28/9/2022 passed in WPC 6462/2022. The operative portion of the order reads as follows. Full stop. From the aforesaid order, it is clear that the consideration as directed, examination as directed is to be carried on by the Executive Engineer Public Health Engineering Umrangso Division Umrangso Dima Hasao. In that view of the matter, the where is that executive engineer Umrangso? In view of that, respondent number 1, 2, 3, 5, 6, and 7 in the considered opinion of this court cannot be brought into contempt in the present proceeding. Accordingly, your names stands deleted from the area of parties. Order at this stage.
Lordship, please to recall the order of that pay level.
Okay.
That the expunging of the
In view of such determination, the order dated 15/12/2023 is hereby recalled.
Halyo.
Be careful.
If my lord, the one number 3, take it in. He says before it's not court that no order has been passed by the higher authority, so that order
We
can.
will see that. Then, if necessary, if there is obstruction of
Who
justice,
will be the higher authority? And that will come into
yes.
play.
We'll see that. Where is that? Have you filed affidavit?
Whether the principal
That
secretary of
observation of
animal
Kelno will be
husbandry is
made
the
by this.
concerned authority.
The lordship may take observed that.
But therefore, if say at this stage, whosoever may not be some other person, suppose there is a order in the chain of implementation, even they are not party in the writ petition, in the chain of implementation, somebody obstructs, then also it will be a
Yes,
contempt.
yes.
It's not necessary that it should be
We
a
will
party.
always offer those persons' name if finance department is
Uh,
creating a problem. Or rather, we request the honorable court and make the finance department official by name party. But this is not a case of that name.
Pension has been held up even after passing of the order.
Order is of consideration.
Well, that cannot
We'll
be
see what is the, let them say that you have not, then you will have to challenge it or
Matter
something like
relates
that.
to my
Now,
pension, well.
one submission is coming that higher authority is creating a problem. Now, who is the higher authority?
Matter
Maybe the
pertains to my
principal
lord pension,
secretary.
my lord. In the writ petition, my lord, no such plea was taken by the authority. Respondent.
No, writ petition, no issues is determined. These are orders. Court has not entered
submission
into
that
the
has
merit.
been made today, my lord. That was not pleaded in the writ petition.
But not
While
pleaded.
objecting.
But not.
The pension and public grants are not made party.
No, that is not necessary because what is a contempt? Somebody non-implementing.
Well,
Is it necessary that whosoever in the party in the writ petition should necessarily be a contemner in a contempt petition.
That's true, my.
If that's true, that's why we are looking into it and issuing notice at the motion stage, not to the all.
Deleting the names, my lord, that will make great difficult. To my understanding. If civil engineer says so, he
No,
cannot.
no. So was the contempt. Prima facie.
This is against the response number 3.
So why should
Order
we
is
need
against
the
the law.
others? Why should we need the others?
Since they are the party in the writ petition, that's why we make.
Is it contempt? Where is your statement that they have violated willfully and how?
No.
Then it's a quasi criminal proceeding.
Highly open.
That's why we can, yes, Mr. You are a standing counsel. Give us the reason. Bring from your department. Contempt is between you, we and the department. Give the instruction. We'll on the basis of instruction, if necessary, we'll implement. Unnecessary, will not bring it.
May I take leave?
Yes.
Highly.
You make a party, because a specific stand has been taken that your regularization was withdrawn. So if your regularization was withdrawn, that order, give a copy of that order to him by open affidavit. Full stop. Mr. R.M. Das, learned counsel representing respondent number 3.
3 and 7.
Hmm?
3 and 7. 7 has already been deleted by your lordship. So 3.
Respondent number 3. Submits that the respondent number 3 has in the meantime retired. However, the present executive engineer PHC Umrangso Division Umrangso has passed an order in terms of this court's order dated
28 9
28/9/2022 in WBC Spencer. Full stop. The said office order reflects that though the services of the petitioner, husband of the petitioner,
Yes.
service of the petitioner was regularized against personnel post by the government of Assam in Public Health Engineering Department by an order dated 7/10/2005, but such regulation of service of the petitioner was cancelled along with 8 other staff by the finance department. Where is the copy? Copy and close. Where is the copy? By which order it was cancelled? This is 2005 regulation. Where is the cancellation?
It's there in the punch.
This is regularization. Was cancelled by an office order number 23 of 2011-2012. 2012, along with some other stuff, and such order was such order was issued in pursuance of an order of the finance government order number FEC within bracket 11 slash within bracket 11 bracket after bracket 61 slash 2005 slash 59 dash A dated 10 to 2006. According to the full stop, it is further reflected in order dated 10/1/2024 that in view of such cancellation, though pension proposal was sent to the Accountant General ANE, however, same has been returned. Accordingly, the petitioner would not have been paid the pension. What to do? Okay. In view of the aforesaid submission, you give a copy. Mr. R.M. Das shall furnish a copy of the order dated 10/1/2024, office order number 23 of 2011-2012. Finance order is not there, no? That is why determination should be made. Had there been a determination, we could have done all this.
It's their duty mal to bring all those documents.
They have done, they have sent it without
What
regulation.
was passed mal 2011, that was not produced mal file disposing of the report.
No, you made a prayer that let there be a consideration. That is the problem. That's why we do not dispose of this consideration. See the litigations. Now contempt is closed. Again, you will have to start from zero.
Unless a loss of issued bailable warrant, all these documents could not have been produced.
Copy to the learned counsel for the petition. Full stop. As the consideration has been made and the claim of the case of the petitioner has been rejected in the considered opinion of this court, the respondent has complied with the order of this court. Accordingly, the contempt petition stands closed. However, petitioner should be at liberty to assail the order of the finance department withdrawing the regularization as well as the subsequent order number 23 of 2011-12 issued by executive engineer within bracket PHC Umrangso division Umrangso, as well as the order dated 18/1/2024 passed by the executive engineer. With the aforesaid, the contempt petition stands closed. Give a copy.
I will.
We have recalled that order. That AG appears. How we have recalled it? Huh? Okay, give the names. Huh? Give a copy of this right now. Huh? Give a copy of this. Give a flag. and show him the record, this bunch. And there is no reason as such why you have cancelled this order. We cannot do in contempt, but this is an Mr. Borpujari. This order is important for him. I have made market pencil mark. Huh? Just after you get it, give a file, this file, so that we can properly note down the orders.
Lordship, keep this. I will take it later.
For that time being, give it to Mr. Saikia. Because a person is, who do not know why you have, show him the record also. If necessary, give it. These are the days of RTI, you can give it. Nothing is there. Give it to him, because there are some orders. Even after that 2017, you have sent pension paper, did something under rule. What is this?
That is why I'm submitting. Unless your lordship has issued valuable warrant, my lord, all these documents would not have.
No, no, but the whole difficulty is that because the petitioner.
All issue is it was not determined and it was a shortcut. Sorry to say. It was a shortcut. Go to the executive engineer and
if that was bad, what happened because of the, he has messed up. He has messed up two issues, regularization and consultation. He has only sought for relief for the consultation without having the regular. That's
But
As per earlier order, my lord, I have inquired with my petitioner, my lord, and arrears payment has not been
Arrear has
disbursed.
been sanctioned, Lordship. The
Sanctioned, but it is-
communication is on record, Lordship.
It is sanctioned, but it is
And
not
GIS
disbursed
is
yet.
under process.
It is not disbursed.
MS are Land Council for the respondent submits that by the by communication dated 15/9/2023, the sanction for payment of arrear salaries /DA in respect of the petitioner has already been intimated to the accountant general within bracket A&E, Assam. Full stop. So for relating to
GIS,
GIS, what is your stand?
that is under process.
As for relating to the payment of GIS amounting to rupees 955,065 for what?
That is arrear salary, Lordship.
Okay, not necessary. Payment of GIS, the matter is under process. Accordingly, full stop. In that, accordingly, MS Bora prays for 2 weeks further time to obtain an apprise this court regarding sanction and payment of aforesaid amounts. Right.
Okay.
Please submit.
He is tried for a small clarification. My lord, the order was passed by my lord.
We listed clarification. Okay. List this matter before appropriate match.
Hello, sir. Hang on, please on like the
My lord, in this matter, I am
My lord,
appearing.
on please on like.
I am appearing for the private respondent, my lord. Today I have checked that they have filed one IA, my lord, without serving the copy to me, my lord. I am the main affected concerned party, my lord.
What is this?
My lord, the case is that, my lord, the petitioner, the private respondent, my lord, he has been, my lord, during his service tenure, my lord, while transferring from one place to another or transferring to the next promotional post, he lost his original seniority. Subsequently, he approached
Is it tourism?
No, my lord. Assam police, my lord.
Okay.
So he lost his seniority. Subsequently, he approached the administrative tribunal, this honorable court, and his seniority has been restored. While restoring his seniority, my lord, the petitioner the
the private respondent came above the petitioner.
Mean you.
Yes, my lord.
Okay.
So they regarding that they have filed a writ petition. Now today I have seen that they have filed another IA, my lord.
This is IA for what?
IA for my lord. I could not.
Provisional gradation list published. Give a copy to him.
Yes, my lord. That copy has not been served to me.
Okay. It is submitted by the learned counsel for the respondents.
Private respondent number 5, my lord.
Private respondent number 5. Copy of the IA has not been served upon him. The learned counsel for the petitioner assures that the copy shall be served to him during the course of that. Accordingly, the matters then adjourned and be listed. Next. Give a copy so that he can respond. Because it's you are seeking a stay of the gradation.
Need to, your lordship.
Yes.
In this matter, I have filed. Sorry. Lord, in this matter, I have filed a counter today. That is not on record. Counter to the IMA.
Okay, what is the issue here?
And the entire matter is fixed on 15th of February 2023 for 2024 for final disposal. The issue is.
What is the IA?
IA we have filed for there is an order passed by this honorable court, the coordinate bench, regarding the promotion. Interim order was passed for promoting the respondent number 6. Similarly, I am also going to retire on 30th of April.
13th of?
30th of April.
Where is the next day matter is fixed?
15-2.
But by this month, council, Mr. K. Chaudhary will lead the respondent in the IA.
So this may be
He is out of station. You will be coming on 8th. Can it be fixed on 9th, Lord?
And
15, my lord.
9th,
Entire
9th and 15th.
IA, Lordship. Because there is every possibility of declaration of the general election on 15th.
Oh, forget about general election. We are here.
Doesn't come. Court order doesn't come in general election.
No, can it be on 9th, Lordship? Because
No, let it be on 15th.
The entire matter is fixed on 15.
Okay, if entire matter is not taken up, we'll consider the IA.
There was an order passed by this honorable court that pleadings are completed, fixed on 15 for final.
Suppose it is not taken, we'll take up the IA. Okay. As agreed to by the learned counsel for the parties, list this matter on 15th of February 2024. In as much as the writ petition is fixed for adjudication on that day.
If the adjudication is with the IA, maybe
I will consider, just remind, not necessary.
Interim pass earlier, make
Interim order pass earlier shall continue till then.
deeply.
Yes, Madam Bora,
My lord.
where is the direction?
9%.
Regular pension and gratuity to be paid to the petitioner within a period of 3 months from date of receipt of this order together with interest calculated. Other part is given. So 9% interest is not given. Have the instruction.
My lordship, we have to impute the present income.
You are here. You are the income.
Then copy may be served to you.
Okay. Equal. By the present petition, the present contempt petition is filed alleging willful and deliberate violation of an order dated 27/5/2013 passed in WPC or MC?
WPC,
WPC? No.
141
No. Order dated 14/3/2017.
25/5.
Where is that starting page?
I'm sorry, Your Lord. WPC 161 page 47.
WPC 1316/2010,
136
1361/2010, and 141 of 2015. Dated kolu na 14/3/2007. Okay. Alleging willful and deliberate operated misconduct. The operative portion of this order is quoted herein below. 41. It is submitted that the petitioner has already been paid the regular pension and gratuity. However, the interest directed to be paid has not yet been paid. Full stop. In view of such submission, this court requests MD Bora, learned standing counsel for Cooperation Department, to obtain instruction whether the aforesaid amount has also been aforesaid interest has also been paid, and if not, the reason thereof. Please this matter on. When can you have this instruction? Next week or at other 7th of February 2024. Full stop. Registry to list this matter showing name of MD Bora, learned standing counsel for Cooperation Department. Full stop. Petitioner to serve a copy of this petition to MS Bora.
I'm deeply obliged.
Petition, the petitioner approached this honorable court by filing a writ petition. Writ petition was disposed of at the most stage, directing the petitioner to file a representation before the respondent number 2.
They said that we have already passed an order wrongly done.
No. I will kindly see the impugned order. Thereafter, I file a representation. The director, after considering the survey report filed by the CDP of my position on upheld, and
No, understand. Therefore, they have even initiated action against that officer.
yes,
Is that it?
yes,
Bora, they have taken action. Now, who is for the respondent?
respondent is not appearing.
Private respondent.
He's as per order.
We'll set aside this appointment, respondent.
Yeah,
And you proceed a press advertisement or whatsoever.
That's better, ma'am. Because if it's disputed party
We do not know at this stage whether she is.
My lord, the
So
order of the
records are
director
also
remains still.
found.
Where is the order of the director?
Relevant page 30, my lord, last paragraph,
It's 30.
my lord. Director is still reaffirm the, my lord, the
Where is that page 30?
repetition, my lord. Sorry, my lord.
Okay. Okay, you do in terms of this director's order. Proceed with that. Okay.
Yes.
Hard. Mr. S.K. Sapravati, learned counsel for the petitioner. Also heard Mr. T. Sutia, learned additional senior government advocate. Mr. Sutia, additional senior government advocate, Assam.
1 to 4, ma'am.
For respondent number 1 to
1
4.
to 5.
Huh?
1 to 5. 6 is private respondent.
1 to 5. None appears for the respondent number 6. Full stop. The petitioner approached this court by filing a writ petition, being WPC.
390.
Where is that?
Uh,
Order, earlier order. Okay. WPC 390/2010. With a grievance that the respondent number 6, who has been appointed as Anganwadi worker, Anganwadi worker at number 170, missing Kathani Anganwadi Center, side over page 25. Missing Kathani Anganwadi Center is not a local resident of village number 2, missing Kathani. Full stop. As the respondent number 6 in the aforesaid writ proceeding denied the allegation and asserted that the respondent number 6 is a local resident of village number 2, missing Kathani, comma, this court declined to enter into such disputed question of fact Full stop. However, in the interest of justice, this court granted a liberty to the petitioner to approach the director, Social Welfare Department, Government of Assam, raising her grievances, and in the event of such an application is made, it was further directed the Director, Social Welfare Department, Government of Assam, shall hear all the parties concerned and then pass necessary order within bracket S in accordance with law. Full stop. Subsequent to this, the petitioner preferred a writ petition, preferred a representation before the director. However, alleging non-consideration of such representation, the petitioner preferred a contempt case, filed a contempt case, being contempt case within bracket C number 157 of 2012. This court in the proceeding of the said contempt petition, the learned standing counsel for the Social Welfare Department on instruction submitted that the date of hearing has already been fixed on 15th of September, 2012 at 3 p.m. in the office of director, and accordingly, the director would hear the petitioners, the director would hear the parties and necessary order as directed earlier and by this court, as directed by this court on 4/4/2012 shall be passed. In view of such submission, the contempt petition was closed. Thereafter, after hearing the parties, the Director, Social Welfare Assam, Guwahati Social Welfare Assam, passed an speaking order after obtaining report from the concerned field officials. Full stop. The determination was made in favor of the petitioner and against the respondent number 6, and finally the following concluding order was passed by the director in its order dated 9th of November 2012, page 30, last paragraph. Full stop. The present writ petition is filed assailing that even after such determination, nothing has been done to implement such direction of the director. The present petition file. The respondent number could you repeat it, Mr.
Affidavit is filed by
Respondent number
2. Affidavit filed by respondent number 2.
the respondent number 2, that is the director, Women and Child Welfare Department, Assam, has filed an affidavit
Paragraph 7 of
in the
the
present proceeding and
paragraph 7 Lordship.
Hmm.
Admitted.
comma, and reiterated its stand that respondent number 6 was not a local candidate from the village.
Yes.
Inasmuch as the D then CDPO has illegally made appointment to the respondent and respondent number 6. It was a further stand that all the original record of the selection were misplaced by the said CDPO, and even after asking, he has not submitted any original record. Accordingly, a departmental proceeding has also been initiated against the aforesaid respondent. Full stop. In the aforesaid backdrop, it is clear that the respondent themselves has admitted that the petitioner is a duly selected candidate for the Anganwadi center in question, being a local candidate, inasmuch as the respondent number 6 is not entitled for such appointment, being an outsider to the Anganwadi center, inasmuch as it is a mandate that Anganwadi worker shall be appointed within the jurisdiction of the specific village or the Anganwadi center. Full stop. That being the position, now it is the director who is to implement its order dated
9/12.
order dated 9/12/2012. Full stop. In view of the aforesaid
9/11.
9/11/2012 within bracket annexer H space 29 to the writ petition. In view of the aforesaid finding, the appointment made to the respondent number 6 is not tenable in law. Accordingly, same is set aside, and the respondent number and the director, respondent number 2 director shall take a call on the order dated 9th of November 2012 and proceed in terms of the said order. With the aforesaid, the writ petition that's disposed.
For a specific time frame.
Such exercise be carried out within a period of 6 weeks from carried out from within a period of 6 weeks from the date on which the petitioner shall furnish a copy of this order before the respondent number 2 director.
It is a topic. This is regarding compassionate appointment pilot. Petitioner mother expired on 25/7/2006 while she was discharging as a peon under the respondent number 7 pilot. And my lord, petitioner name has been recommended by the committee headed by the additional principal chief conservator of forest. My lord, whereby petitioner name appeared as a serial number 645, page my lord 16. My lord,
Yes.
my lord, till then this select list has not been rejected. And my lord, that on 18/7/2015, my lord, one advertisement published, my lord, whereby some other candidates were selected for grade 4 post, my lord, in the year 2006. My only limited, my lord, there, my lord, that in the year 2006, those who were selected, my lord, they were not from in the year 2006. My lord. And till date, my lord, they have not filed any affidavit.
2006,
Yes.
we are in 2021.
Yes.
This cannot be a regular mode of appointment. And you have approached this court in the year 2018. Where is your selection?
Selection, my lord, page 16, my lord. Type copy, my lord. This select list has been forwarded by the conservator of court. Annexure D page.
Where is the High Court's order, earlier order? 16/9/2013.
That was not annexed.
Page 16.
Yes. Relevant for
It was in 2013.
Yes.
So you have challenged this selection.
Yes. Only matter that 2006, those who were selected.
Where are the other respondents?
Other respondents, my lord, BTCA and
No,
Forest Department.
suppose they have earmarked certain vacancies. So against year they have made appointments. Isn't it?
Yes.
To give you, assuming for a moment at the year 2021 we give you an appointment, or we felt that this election is bad, we'll have to set aside this. Isn't it?
Yes.
Where are those persons before us?
That I'm only against that advertisement. I have
If you are only against the advertisement, that means the person inside the advertisement is, this is not an advertisement, this is a selection.
Yes.
Advertisement that for intimation, they have used the wrong word. This should have been a notice.
Yes.
They have already selected this. This is a select list.
Yes.
Your name is not there. You have challenged this select list. Where are the persons, other persons? We will dismiss it. Hard. RS Dury, Learned Council for the Petition. Also hard.
Number 8
Chakraborty for exponent number
3.
And Mr. Bora for exponent number 2. Two and 7. The present writ petition is filed assailing a select list dated 18/7/2015. 18/7/2015 within bracket annexure F, annexure F, whereby the state level committee in its meeting held on 1/4/2015 challenges and order whereby a select list for appointment on compassionate ground against the vacancy for the year 1996 to 2010 in the forest department was published. Full stop. Case of the petitioner is that the petitioner, who was also a candidate, has wrongly been deprived from such selection. Full stop. The mother of the petitioner was an employee under the forest department who died on harness on 25/7/2006. Full stop. 2006, and accordingly, the petitioner filed application before the employer of the mother for compassionate appointment. Full stop. Next, the conservator of forest within bracket headquarter prepared a proposal empaneling as many as 805 candidates for appointment under scheme of compassionate appointment for the period with effect from 1996 to 2010 against the earmark quota of 5%. Full stop. Such communication was forwarded to the Principal Secretary to the Government of Assam Environment and Forest Department. Subsequently, the state level committee constituted for this purpose, after consideration of the respective claims, held in its meeting on 1/4/2005 in the conference room of Chief Secretary Assam, Dispur, decided to recommend the names year-wise from the year 1996 to the year 2010 as reflected in the impugned advertisement/notice dated 15 notice dated 18/7/2015. Full stop. What is your ground of
Only
challenge?
that, my lord, they, 2006, my lord, those who were selected, my lord, they were from different years. That is on.
The basic ground for the petitioner is that the persons who were selected against the vacancies of 2006 do not belong to the said year, rather to a different year. And thus, the petitioner, who actually belongs to the year 2006, inasmuch as his mother expired in the year 2006. 2006. Full stop. However, full stop. However, the selected candidates against vacancy of 2006 numbering 9 are not arrayed as party respondents before this court. Full stop. In the event this court tells that such selection is bad, comma, the said person's number in 9 might have to give away to the petitioner. Full stop. Such course of action cannot be taken when these 9 persons are not before his petition, not arrayed as a respondent in the present petition. That being the position, this writ petition cannot be entered. Full stop. Another aspect of the matter is that the murder of the petitioner expired in the year 2006. The select list was published in the year 2015, and the petitioner approached this court assailing such select list in the year 2013, that is 2018, that is after 3 years from the date of publication of the select list. In this count also, this writ petition cannot be entertained when such writ petition involves appointment on compassionate ground. Accordingly, in the considered opinion of this court, this writ petition is devoid of any merit. Accordingly, same steps dismissed.
Also for the PTC.
BTC, Mr. Bora.
And the health department also. So paying
What time is the instruction, Lordship? My name is in this time, madam.
Just you see earlier order it is 1512. I think you'll have it, and 2212. Okay, that order is reflected. You please have it. When can you? Instruction.
After 10 days, madam.
Okay. Mr. S. Bora, Learned Counsel submits that he may be granted further 10 days time to obtain instruction in terms of this court's order dated 1512, court order dated 6/12/2023, 15/12/2023, 15/12/2023. So prayer is allowed. Please this matter on divided. Fine.
Earlier occasion he was absent.
None appears for the petitioner on call. None did represent the petitioner when matter was called on 22/12/2023. Accordingly, representation is dismissed for non-participation.
My lord, it is the task of
Record was called.
Yes,
Record has come. The voluminous record has come. Lordship. What time will be required, Lordship? That's now received.
you go through it. If necessary, go to Mr. Vishal.
Next
Not-
week, Lordship. Next week, Lordship.
Next week? No, not today. Next week.
Next week.
Next week. Okay. Mr. Sakravati, Learned Counsel, representing the state, submits that the record, he has received the record in terms of this court order dated 13/12/2023. First of, however, he requires some time to go through the same. First of, Mr. Boisha, Learned Counsel, submits that he may be also allowed to go to the record in presence of the Learned Counsel, Mr. Sakravati. Full stop. Prayer not being objected is allowed. Full stop. The Learned Counsels may go through this record and release this matter on
Next week.
okay. You also go through it. Learned Counsel representing the part and release this matter on 8th of February 2024. Full stop. Learned Counsel for the parties may go through the record in the meantime.
Public.
So that we get proper assistance. Both of, because both of will have two views on the same record. So go to it.
Please, your lordship. This is the second round of writ petition regarding compassionate appointment. The application was filed within time. And thereafter, as it was not placed before the DLC, the petitioner had approached this court. Thereafter, directive was given by this court to place. Accordingly, it was placed.
There are some queries from this court last occasion. Are you ready with that query? If you are ready, we'll proceed. Halfway, don't say I need time. 13/9/2021. Are you aware of that order? No, you go through it on the prayer of the learned counsel for the petitioner, matters then adjourned and be listed. After a week, in the meantime, he will he will advance arguments in terms of this court's order dated 13/9/2020. You go through it and properly.
If your lord,
Yes.
kindly have a look at the order dated 6/12/20 passed by your lord.
Lordship, instructions not yet received. We have written to them on 7/12 itself. So far, not yet. I'll send a reminder.
Okay, Mr. Bora, learned counsel, appearing for the director. Director of what?
So, Women and Child.
Director of Women and Child Development submits that though he has communicated to the director, however, no instruction. However, he has not received any instruction. Full stop. Accordingly, press for an adjournment. Prayer is allowed. However, if no such instruction is received, the court may consider for personal appearance of the director apprise this court. Personal appearance of the director to clarify his stand in terms of this court's order dated 6/12/2020.
Yet make I read.
List this matter on 12th of February.
Highly appreciate.
Yes, Kemprai.
Lordship, our affidavit is ready. We have not filed it, our affidavit is ready.
When will you file it? Tell us. On last occasion, we recorded that 2 weeks time to file affidavit.
Lord-
She has received instruction.
Lord-
Now
Yes.
morning somebody came and said that
Yes.
we needed it. We have not granted it.
Lord.
When?
10 days.
Why 10 days? On last occasion, you said that I have received instruction.
Affidavit is not ready, Lordship. We have prepared it, but because of some difficulty with the officers, we could not file.
Ms.
10 days, sir.
Kemprai, Learned Standing Counsel for KASC, submits that though she has prepared the affidavit but could not file the same due to some difficulty of the officer who need to swear this affidavit. Accordingly, 6 for an adjournment. Prayer is allowed, please after week.
Obliged.
In the meantime, affidavit be filed. Keep it there.
The matter
Yes.
The petition started 1996. Then I applied for opposite appointment, and my name has been commented by DLC at page 14 lot. TL number 7.
Serial number
Page 14 lot. TL number 7 lot.
6/7.
7.
Deputy Commissioner Gwalpara.
Recommended by no 7 lot.
Page.
Page 14 1/4.
1/4. Okay.
Annexed.
Yes.
7 my
Puloranjan Kumar.
yes sir. Single post 1 post. Sole candidate.
Okay. How your case is dealt by the state level?
State kindly turn to page number 19 lot. This is a communication from the department.
Page?
Page 19. Sorry, page 20 sir.
20?
20. Below 11 TLC seated on held on 28/2018 and
Where? Page 2, I'm at page 20.
20.
20.
Below 11 lot, serial number 11.
Okay. So far, so after careful.
Yes, sir.
Hmm.
So after capital, the LCLC meeting held on 28/2018 lot. Then my name has been rejected lot.
Where is that?
Serial number 1 lot.
Oh.
All the proposal of Tezpur Building Division, Tezpur Electoral Division, Nagaon HS Division, Haplam Building Division, Nalbari Building Division, Guwahati Building Division 1, Walde Party Building Division, sorry, 2, then 1 is my lordship. Then mechanical NH division, so and so lordship, and in the below lordship, could not be recommended as ceiling of 5% has been already made.
Your is Gwalpara. Where is the Gwalpara?
I'm not Gwalpara.
You are for
Guwahati lord.
Guwahati division number 1.
We are
Okay.
division number 1. Executive Minister PWD Guwahati.
Who will file affidavit?
We have not yet filed an affidavit. But
We know that.
if I have to take just one particular fact, the petitioner started filed in 2012. If we have to go by the Devendra Tiwari judgment,
Oh, forget about it. Not always. We cannot give license to you to do whatever you like, taking note of a judgment. In a given case, we will apply that when the petitioner is at fault. We will not allow you to do this taking of the judgment. When petitioner is delayed, he is 2006 years. Why have you then considered? Why have you not rejected his case on the ground that it's a delayed claim?
we have actually considered in the year 2019.
You have. We want the reason. From where do you get that there is no 5%? From where? You are not monarch. State level committee is not monarch. They will have to give reason.
If I may ask my petitioner to give me a copy.
Give a copy.
Because the petition copy is
Okay. Mr. Bora submits that he may be granted 10 days time, 2 weeks time to file affidavit in opposition. First, prayer is allowed. List this matter on 12th of February 20. Possible?
It will be on 16th of February.
16th of February 2024. First of registered to list this name showing is registered to list this case showing name of Mr. No. Some other GSM will come and say that I was not there.
Also, PWD council's name.
PWD is not required because PWD has recommended his name is shown. You have decided even deputy commissioner we cannot bring them. According to them, vacancies are there. Your name is sent. Now we'll have to satisfy. No, district level committee is wrong. Though there is nothing. We'll have to show by record. We'll throw him the road.
With regards to this vacancy position in the department, they will be in a better.
From where does SLT has decided?
That is what I have to.
You will have to have. This is a decision of the SLC. You cannot say that we do not know anything else. We have just written it.
SLC, if I have to.
Cannot know. Yes, Bora. No, Bora. Learned. Additional junior governor. Yes. You are responsible.
Lordship, then prior to 16 February, then because I'll be on leave.
Okay, give a date.
From
So
February.
that's why 116.
No,
that
prior to February 16th. Because
okay,
I'll be
give a date.
from
12.
February 15th.
12. 12. Have it. If actually there is no vacancy, we'll throw him the road.
As per office they may question for other departments.
There we have doubt. For how much here your name will be kept in a waiting list?
So it
It's
is
a
other
compl-
department.
No, we cannot allow all this. We have framed certain issues and asked the senior government advocate or AG to address it. You will say 2 years, you will say unlimited waiting list. What is this?
We are directed to produce the original record. We have got it.
And you were also directed to bring
Yes,
the
but
original.
I have brought.
Mr. Chutia, both of you go through both your fraudulent documents. According to you, you are fraud. According to him, according to you, they are fraud. No, give it to Mr. Doctor and Mr. Chutia.
No, I have no doubt about that document.
Okay.
My
No, you know that.
Yeah.
Whatever your Mr. Chutia, just show him and what are the deficiencies, whatever you
Yes,
apply.
yes, yes.
We'll take it this matter day after tomorrow.
Yeah, tomorrow.
Okay. Mr. Chutia submits that the record, both the learned council for the party submit that the records in terms of this course order dated 19/12/2023 have been received. Both of the learned councils may go through their respective records / documents and assist this court and argue and advance their arguments before this court day after tomorrow.
I may be permitted to send it to the SEBA for verification. Madam. He has submitted.
Okay.
Well, because I cannot say.
Okay.
They will
Show them.
Yes, yes.
Show them. No
Record
problem. He's confident, that's why.
yes.
Required by law, initiate a police case against if it's wrong.
He's confident. So that's why.
Okay,
okay. Okay. So then today is Monday. We are taking it on Thursday. Thursday.
I will send it. Madam.
Okay, you send it. You have these are the non-adversarial.
Yes, yes,
We'll
yes.
say because we do not want an ingenuine person to get benefit and a genuine person to suffer. That's all.
Yes.
And you also assist us not as an adversarial
No,
litigation.
no.
Your experience.
Record says
Okay. We'll see. There may be sometimes record. There may be also mistake. We are not commenting anything, but we want a decision to be made correctly.
Impartial.
Yes. Listen first. You go through it both.
That part is my thought explanation of the petitioner.
What is the law in this regard?
Law is my lord, the standing order is enacted by them, my lord. The standing order covers my lord an injured person, injury sustained during
No, we understand. The standing order says, suppose if you got an injury during the training and you are disabled or you cannot continue with the course, there is a scheme for those persons. Now, do you propose to say that all persons at any rate are bound to be covered, or there are some criteria to be fulfilled, or there is a competition? What is this? Let us see the scheme.
Here, my lord, is wrongly interpreted. My lord. There is two basic training and undergraduate training. The person will be in service, my lord, with service confirmed, my lord. My lord, in during the duty and some there it is there, my lord, and something is happened, my lord, they are accommodated, my lord. Here, my lord, he is not completed basic training. So he's in the basic training he injured, my lord. So he claims this as per this.
Suppose a person, see, we'll address this. That's why I'm asking what is the law? Law as regards a person is put to a training. Okay? He was duly selected.
Yes.
During training, he got injury and become disabled for a moment.
Yes.
He may not be disabled. He has become disabled for other purpose. So will you throw him in the street? Okay, forget. You have come, you have injured. Go home.
My lord, this, one thing, single judgment was passed by Honorable Justice Buzurgula. My lord, in this case, CISF matter. My lord, when he was medically fit, my lord, he was terminated, my lord, and this honorable court not entertained, my lord, that's not allowed. It is their judgment, my lord.
No, he was medically fit.
Unfit, my lord. It's not medically, my lord. He was medically unfit, my lord. So, my lord, his service was terminated, my lord. Subsequently approached the honorable court, my lord. The honorable court not allowed his parent. This is their result.
You same in the law.
Yes, my lord. Law,
What is the law?
Law, my lord. Law says, my lord, there is no such specific law, but one thing is there, my lord. Is, my lord, as per rule, my lord. I'm reading, my lord, there is. It says, my lord,
My lord, as per Rule 16, period of service, all members of the force shall be enrolled for a period of 3 years. During the period of engagement, they shall be liable to discharge at any time on 1 month notice by the appointing authority. At the end of the period, those not given substantive status and shall be considered for quasi-permanency and under the provisions of 1965. Those not declared quasi-permanency under this rule shall be continued as a temporary government employees unless they claim discharge as per schedule to the act. Those who are temporarily shall be liable to discharge on 1 month notice, and those who are quasi-permanent shall be liable to discharge for 3 month notice in accordance with the schedule as amended from time to time. 3 years as per rule.
That is not the issue. Sports question is, that is, you have a power, they are not permanent 3 years. You can issue a notice, you can terminate. But here is a case where he became ineligible or disable, whatsoever word you use, because he got injured during his training. Is not it? So far relating to the acquisition of inability or disability during course of employment, there are certain provisions. Okay, that they will get disability pension, and there are some other pensions, these, that. Because when you say that, no, we do not need you because you are not fit, and presumption is that he has become unfit if that was not at the entry level for the reason of his service. So some pensions, disability, and what are other pensions? That is in case of when he was in service. Now there may be a distinction here, a training, he has not entered into the service.
Yes.
Training and service. But while on training, he got injured. Not otherwise. During training, he got injured, and now he is unable. And you said you are not fit. You will have to go, because before completion of training, he was fitted 2-3 times. So this is a status where it is a grade 2. So what is your principle so far relating to this kind of person who got an injury in training and becomes ineligible to continue?
So far, my lord, is my lord, the annexity, the standing order, my lord. Here, my lord, based on 49 of the requisition, my lord, it says my department has 3 categories of disabled person. Those who are disabled due to injuries sustained in the action against terrorists, / anti-social element, insurgency, Naxalites, while while maintaining law and order, internal security, and undergoing training or any other bona fide duty.
So undergoing training.
Here, my lord, is my lord, undergoing training, my lord, here means my lord, this person to service is confirmed.
Where is that?
Because this is the basic training. But is the main
No, understand.
Yes.
Your argument must be not from that you like to argue it. It cannot be.
And only
You say that this point is that this training will necessarily mean training after confirmation. Where do we get that? You're saying will not do.
Yes.
From where do you get that this training is interpreted as training after confirmation, not training before confirmation?
In that part, I have not giving inspection, my lord. The thing inspection. And another point is, my lord.
What is the ground of rejection? That is the ground of rejection.
My lord, there's earlier there's a rejection. There's the direction from this page 85, the relevant. Here, my lord, says from this para 8, from these documents filed by respondent on the direction of this court, it can be concluded that there is a scheme of rehabilitating the injured person injured during training. Therefore, writ petition is disposed of with direction to the commandant of the battalion under whom the petitioner worked last, Respondent number 5, to refer the case of the petitioner to the Department Revision Board at the earliest but not later than 3 months from the date of receipt of certified copy of the order for a critical examination of the petitioner's case to determine his physical and mental capability, job requirement, etc., and hereafter to recommend the case for appointment to any suitable job as per standing order number 4 of 2011, which has been amended by order dated 14/8/2012. Since the petitioner has been out of job for quite some time, all concerned are directed to complete a whole process within a period of 5 months from today. This is made clear that the termination order, which is under challenge, it will not stand as a bar in considering the case of the petitioner for re-evaluation as stated above. My lord, here, my lord, is only that this termination order are not satisfied, my lord, and direction to my lord, consider the board, my lord. My lord, I have this annexure is impugn order in page 87, my lord. This is, my lord, as part is only part is the reflected the observation of the board, my lord. The disability revision board, my lord. This page 90, my lord.
Where is the recommendation board?
My lord, board recommendation, my lord, I have filed a separate affidavit, my lord.
Where is that?
149, my lord. In page 14.
As part of the order of the honorable court, my lord. This is 149. 150 is the, my lord, is the medical opinion and recommendation of DL.
Page number 50, examiner. He is for competitive medical opinion.
He cannot be even a telephone operator.
My lord, only my lord, there is my lord of technicality, my lord, this fair my person, my lord, only the set aside that annexure 23 page 87. This was only the reflection of the board board observation, my lord. And there,
Yes, what do you say, Mr. Khalid?
another thing, there is another order, my lord, is dated 27/10/2020. It was not challenged, my lord. In this case, I earlier produced before the other court, my lord. that, my lord, hence the petitioner's muster cannot be rehabilitated in service at a stage under the prevent rule organization. This was not
You
clear,
are sitting in a read court.
my lord.
You are sitting in
yes,
a read court.
And my lord
Yes.
is so far, my lord is another, my lord is the earlier order, my lord, was not satisfied the termination order. And this in particular return they
No,
have
he
not challenged.
is not on the termination. His case is that he is entitled under scheme. You have assessed him physically.
Yes.
You have assessed him physically. And your scheme says that those who are not physically fit, for those these schemes are there because telephone operator, bus attendant, these are the jobs. And your committee says, no, we require the fit men. The scheme itself is for those persons who are not fit.
My lord, this my submission report,
Okay. Yes, Mr. Kadir, what you say?
My lord, this is the second round of litigation, my lord. All the aspects, my lord, this honorable court has already, my lord, adjudicated, my lord, in the earlier decisions, my lord. And my lord, from their end, this pending order on the query of this honorable court that if any other ordinary job is can carry, then they have, my lord, by PTP this standing order submitted. And based on this standing order, the earlier order, my lord, is passed by the honorable court, my lord. And my lord,
But they have decided, no, you are CRP, even if a telephone attendant is required to be physically active. Anytime there may be ambush, you will have to run. You cannot run.
my lord, paragraph number 7, page number 85, my lord, the honorable court has observed that as per standing order, my lord, that there are the jobs which have been, my lord, mentioned, then it not go to combat, my lord, for which, my lord, for disabled persons, my lord, these jobs are created.
See, as the law,
Yes.
these we have already read.
Yes, my lord. So, my lord, as per standing order, my lord, is in the standing order.
They have their satisfaction that you are not fit even for this. Can we replace that? No, he is fit, take him as a. What is wrong in that order? Let us see. Let you argue on that.
Yes, my lord, the medical law, my lord, the page number 150, the opinion of the board is there, my lord. On the examination, my lord, he has traveled from Silchar to Chhattisgarh, my lord, on his own, my lord, and attended this board, my lord. Here, my lord, the local examination means the two injured parts of his both knees, my lord. It is mentioned, my lord, that no swelling, no tenderness, no, my lord, capitas.
But you read others also that he cannot run. We need a person. CRPF is an active.
Yes, my lord.
You argue in a different level, not. Don't repeat all those things.
Regarding, my lord, combat is mentioned, my lord, he is not fit for combat duties. For combat duties, my lord, the standing order is not, my lord, for the combat duties. He was earlier going. This standing order is only for, my lord, those persons, my lord, who are not fit for the combat duties, my lord. For which, my lord, this standing order, the earlier court, my lord, my friend has, my lord, read, my lord, the part. Yes, this honorable court, my lord, after going all these, my lord, directed the court, my lord, the for a moment, my lord, the operative part of the judgment, my lord, may I read the last.
No, will not read that. That is something. Don't read unnecessary.
86, my lord, directed that, my lord, the operative part, my lord, that and thereafter to recommend his case for appointment, my lord. After examination, the 86 part, page 86, my lord, this honorable
If
court.
we go by your argument, your whole scheme is gone. Three categories of disabled persons.
Yes.
Those who are disabled due to injuries. So primary consideration is disability.
Yes.
Okay. Which includes during undergoing training. Okay. See, When the medical officer in charge is of the opinion that there is no sign indication of improvement and the individual is not fit for normal active duty, the case of the individual should be referred to the Department for Rehabilitation Board. Okay? So that includes a person who loses his limb, including a person who is fit with an artificial limb. You take your seat. You have no role in this case. Take your seat. Don't say your process. Page 50. So you will have to make a determination whereby he can be rehabilitated within the force by assigning jobs mentioned in para 7 and 8. And or he is not fit for any kind of duty. Specific reason and medical opinion. Therefore recommended to be invalidated out. These are the consideration you will have to take. What are the paragraph? Runner. Suppose he cannot run. You have a finding. Telephone operator. Okay. Attendance in our room, welfare center, school bus. Salespersons in canteen, cooperative floor mill. RTO at railway station. Copywriter. Mess constable. Serviceman. Any other specified job considered suitable for time. Okay, so you'll have to consider any of this. Where is your finding that he is not fit for anything? Your finding is that he cannot run, so it's a combat is not possible. Then your whole scheme is gone. There is no scope. You say even you fit artificial limb and put him.
That is why my training, basic training and undergraduate training. So we have submitted in our.
Where is that? That is not the case. Your case. How can you argue that?
Because
where is your findings in the DB code that he is not completed the training, therefore he is not entitled?
My lord, it is there, my lord.
Where is that? So ask.
My lord, recommendation, my lord, for my lord, page 150, my lord. Mustaq Ahmed has not completed his basic training. At present, after having attended injuries from both, so he will not be able to complete his basic training in future. Nor he is able to take work and CRPF is filed. So it is a basic training. So we have distinguished these two training. This person already confirmed his service, the 3 years. If there's something is happened, and this office order come attract their they will get that benefit.
A person will be appointed in a railway station, according to you, without a limb. What is the difference between having a training and not having the training? You will have to read the scheme as a whole.
Yes,
see, a young man who entered into a training, there is no doubt that he was fit at the entry. He was duly selected. During training, he got injury and he has become disabled. So you will throw him out. Go. Even dogs are being given when they are disabled in your training with proper respect, with pensions and all.
The program will be there, when in basic training, is they also for this constable or they are good in.
Heard the learned counterparties at some length. The basic grievance is irrationality committed by the board in considering the case of the petitioner for rehabilitation in the force under a scheme formulated by the Union of India. The petitioner admittedly got disabled after sustaining injury while undergoing training, basic training. Mr. Mehdi, learned counsel for the petition, for the respondent, argues that such scheme is not available to those persons who are undergoing basic training, but available to those persons who has already completed the basic training and are regular employees, are confirmed employees. Full stop. The scheme, reading of the clause 2 within bracket A of the scheme in the prima facie, in the prima facie view of this court, has not made any distinction between training and basic training and basic training and a training undergone after confirmation. Mr. Mehdi is to address this court properly from where he has advanced such argument. Welcome. At this stage, Mr. Mehdi had pressed for an adjournment. Prayer is allowed. Release this matter on 8th of February 2020. Your presence is not required. 8th of February for further hearing. Your job will do
Only
for further hearing.
I may point out only that my court is not a party in this matter. It is my duty to point out before it is not.
Yes.
Highly.
Item number 16, my lord. We are required to file affidavit. The affidavit is being filed during the course of the day, my lord.
Okay, where is Mr. Borguya?
It is here, my lord. Mr. Lahon is representing.
Okay. So they are filing an affidavit. Okay. Mr. U.K. Goswami, learned counsel, submits that an affidavit is being filed during the course of the day. Accordingly, he seeks an adjournment. Prayer is allowed. Please this matter. After 2 weeks. After 2 weeks, in the meantime, the petitioner may file response.
Hello.
Lordship, item number 70, Lordship, I may take the Lordship indulgence. I have a matter in court number 2. That's why
Okay,
I'm saying
item
number 17, Lordship. Lordship,
yes, petitioner.
He filed a,
I'll file a reply, lord.
You have filed affidavit.
APSC has filed an affidavit. I am from the Industries Department. If required, I'll file an affidavit. In the meantime, he'll file a reply.
Okay.
I'll file a reply. Not 8. I have already filed my
Okay.
So 2 weeks time.
Mr. D. Das, learned counsel for the petitioner, prays for and is granted.
I require 1 week time.
1 week's time.
2 weeks time.
2 weeks time to file reply affidavit to the affidavit in opposition filed by the APSC. List accordingly. The other respondents may file their response in the meantime.
But may I pray for a quick date?
Give a date. Just
16th.
16th of? Just okay.
19th.
19th.
19. Apply.
Thank you, my lord. I have received the instructions, Lordship. After I file an affidavit, Lord.
Okay.
2 weeks time.
Where is Kayum? Okay. 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 The learned standing counsel for the health department submits that this court's, in terms of this court's earlier order, it is so. Last order. She has received instruction. Accordingly, prays that she may be granted
2 weeks.
2 weeks time. We are having instruction 2 weeks
Yes,
time to
yes.
file affidavit in opposition. Prayer is allowed. List on. Give a date.
Apply.
Lian,
My lord, we have received one letter from the department dated 11th of January, and the department is seeking 3 more weeks time to obtain instructions, my lord. The whole thing is under process.
your finance and taxation.
My lord, I'm
You
appearing
are
on behalf
H.
of
Borua.
H.
Huh?
H. Borua.
H. Borua. Mr. H. Borua, Learned Standing Council, Finance and Taxation Department.
My lord, I'm appearing on behalf of P. Gogoi, Standing Council.
Appearing on behalf of D. Gogoi, Standing Council, Finance and Taxation Department. Press for 3 weeks further time to file affidavit or
My lord,
to further 2 weeks time to enable him to obtain instruction and file affidavit. So prayer not being opposed, stands allowed.
A date.
Huh?
A date.
List this matter. Weeks, after 2 weeks. 19th of February. Yes.
Hello.
On the last, PWC direct take and file your affidavit.
Give the copy of the decision.
Your Lordship, otherwise it's SLC minute. It's there at page number 18. The same thing has been stated in the SLC. Not within 5%.
So file an affidavit. Why do you need this? That is already on record. We'll see.
PWC was that.
Mr. Ardhar, Learned Council for the petitioner, press for further 3 weeks time to file affidavit of prayer is allowed. Please take.
Okay.
Yes.
Signature party. One advertisement dated 21.
We understand. Have you taken steps?
Yes.
Yes,
Yes,
Borua.
Lordship, the vacancy is not available. Otherwise, it is covered by the order and judgment annexed by him. Petition.
Which judgment?
This case is covered by the judgment passed in order last page number 95 of the report.
But that cannot be a ground if you have committed a mistake. If he is in the benchmark number he has acquired, if you have deprived wrongly, do whatever you like.
There
Under this judgment also, then under this case may be discussed.
Day after tomorrow. We'll pass the order day after tomorrow. Okay. This is the category scheduled caste and or
Yes,
taking going. I have also passed some judgment
Yes,
in this
yes.
thing.
Yes,
Isn't it?
yes, sir, yes, sir.
What was the judgment? We dealt with all these matters.
Hemant
Dilti, huh?
Hemant Pokhriyal.
Hemant Pokhriyal. Just take note of this. Learned Council for the petitioner submits that his case is covered by the decision of the Honorable Apex Court in Gaurav Pradhan and others for the state of Rajasthan and others. Full stop. MSS Borua wants to go through the same. Accordingly, release this method day after tomorrow. We'll pass that order. In the meantime, we'll get that order. Okay? Day after tomorrow. holiday. Holiday, 1st of February. Okay, we'll pass that order. I will also find out the judgment. It was, what was that?
Gaurav Pradhan.
No, that other judge,
Hemant Prokriya.
Hemant Prokriya. I think,
In my repetition, page number 87, your lordship, 87.
87.
At paragraph number 7. It's page number 87, paragraph number 7. After perusal of the order dated 7, it was passed so and so, and also judgment of the decision.
Okay. We'll go through it, huh?
Fine.
And we'll pass that order.
This judgment is in her after they don't have that.
Vacancy cannot be. If you have committed mistake, you have mistake.
Deeply obliged.
We'll pass day after tomorrow. Now on first, huh? Mr. Nayak. This is not, we have dictated something.
That is what I was,
This is not, this is the order.
because I was thinking that I will continue. No, it's lot of में at this part in the final order also. I cannot.
This was a decision. This order is on record, 1412. That is not a problem. Thereafter, we have dictated something on,
In fact, lot
on 2112.
wrong direction.
On 2112. The order you have given is already on record, 1412. This was our prima facie view. Then he produced the record, argued, and we have dictated many things.
And your lordship expressed the prima facie satisfaction that reasons are there in the record.
That also we have dictated. Take down who has taken dictation on 2112. No, your order is already on record. That we have uploaded for the first, that prima facie satisfaction. Having that, we call for this.
On the day your lordship.
Thereafter we reproduce, and I think I made a dictation.
Yes.
Almost everything is dictated. If we get that, everything will be easier. I can share a copy of that with you also.
At some of the judgment, I had to rely, my lord.
Let him, you will have a chance to reply. We'll determine next week. Next week means this week only. Or you have any problem?
No problem. At the earliest stage, your lord.
No, at the earliest. We'll finish it.
They are going to be returned.
We know that. That's why we have taken. Because we have record, let me see. Let's just wait for a minute. We'll call the other matter. Just wait for a minute. You remember, now I have dictated.
Yes, I remember.
I was present.
So if
but that copy was not available in the record.
Because that has no printout has been given yet. 1412 is fine. 1412 was taken by him. That was already on record. But subsequent to that, we have dictated.
Yes, I remember.
So that will help us, because whatever on record, that also we have recorded.
Yes.
Isn't it?
It will be easier for me.
All those pages where how the proposal was started, that we have for the future understanding we have recorded.
30-40% already been
recorded. Okay, just wait.
Another date, lordship, until that, if your lordship wishes.
No, just let me have the copy. We'll not taking up the matter today. We'll give a date. Just I want to see that portion. If not, then again I'll have to do the whole exercise. Then I will go through the record again.
Probably
I think it will be in the live streaming.
It will be in the live stream.
Yes.
Okay. Anyway, next case. Just wait for a minute. Any serious urgency?
Urgency is there, lordship. The stay is operating from 2017.
Yes, that's there. 8 pages. 8 pages dictation. Just rough dictation, okay? Do you want a copy of this? Where is Nayak? Huh? Let's just remove the first portion, judgment and verdict. Remove this portion and give a copy to them.
If lot
This
is not prefers not to upload this lot, can you give us a copy of the same?
no, we are not uploading because
Lot.
absolutely rough. This is for the final dictation.
Okay.
So take a copy from it, just remove this part.
Lot
can take today also tomorrow.
Further lot is
Give a date. I also go through it. What was? You have your judgments are also recorded. Secretary's judgment.
some of the suspect
We have we have recorded first part, the facts, basic salience.
yes, I have the copy of type six.
From the facts we have from the pleadings we have recorded the facts. Then Secretary's argument.
We in fact your lordship has decided one for.
So
far as that
then Secretary's concluding, then Mr. Nayak's argument. At that time, Mr. Nayak wanted to rely on some judgment. That's all. Okay, you will reply. Remove the judgment portion and give this copy to both of them later.
First of February পুরোহিত any exercise
we can give you if we give we can give you many things. If we not will not.
That is even if it is taken on fast lot, he will he already
Because with the lordship will pass
See,
the-
in between there are some otherwise.
So it would be at the earliest because the petitioner all
on
the time
13th
there,
lot, 13th of
June, at the
retired quarter
at the earliest man.
Agree with it.
My lord, only February, my lord, at best lordship may 6.
6th, okay. 6th is possible.
Lot.
Already 2 long methods are fixed.
The otherwise, first lord, otherwise, my lord, all the time they are trying, my lord.
A little bit of What is the urgency?
Lordship,
Man is ultimately acquitted.
Lordship, the acquittal may be their Lordship, but concealment of fact, that is also their Lordship.
But he says that he was not even aware.
So that is according to them, Lordship. I have my affidavit where I have stated that he is aware. Even Lordship,
Where is that affidavit? Show us. On what he said, I was not aware. How have you
Lordship,
now ownership upon you that he was aware? Where is that?
Lordship, even after he came to know,
Hmm.
it is his duty to intimate, Lordship. That was also not done. That is part. And one obstructing case is there,
What that
Lordship.
will terminate the person? Is he bad in service?
He
He's a junior engineer.
He is in probation, Lordship. His services, the rules and regulation of acceptance of offer of acceptance is very much clear that if there is
Here
any kind
there is no urgency. We'll hear it. Rule is issued already. What?
So
We'll
finally,
hear. Not a pressing case to be heard on a miscellaneous. We'll hear it. March. Many pressing cases are there. Pension. Taking take his service. Was duly selected. We'll see whether that is fatal for him. 7th of March. What is the pressing need, madam?
was from the allegation that different case and trial is going on. So that one getting department. But he has contested like the first of I state that the and that is first material
Where is the supposed?
first proposed on the page 24 and 30.
What happened to the criminal case?
That is some look for some other
Where is the inquiry report?
that the reply I have filed on page 27, that is first proposed reply, and then page 28 of the third file. Inquiry.
This is inquiry, Annexure 5 is inquiry report.
Yes.
They are taking a risk. Serious risk.
Stated that for the statement taken of the IO and the victim present
But in fact, there was no such statement recorded from the very side in my presence. No chance was given in process the as per information. I was on call then some signature. Nothing there. Signature.
We'll have to see the record then.
Record for the art or already record call for
On the basis of the, if there is procedural rep, we do not know. But on the basis of the findings in a departmental proceeding will not enter. If there is a procedural left you can show which prejudices you, then of course we may remand it. But you are taking a risk. Even if we decide your acquittal will not help you. Even in the case.
where about to process the
We'll see that. We'll remand it. Let them cross-examine. So let us see the
I may
record.
take the help of an advocate.
So learned MS R. Chaudhary is present. MS R. Dhar, Mr. R. Dhar. However, none appears for the respondent. In the interest of justice, matters then adjourn and be listed.
It is
52 matters. March. Huh? 7 March.
Okay.
Registry to show, the registry to reflect name of Mr. R. Dhar as the counsel for the response.
Okay.